Young, and we're here to ask us anything tonight. We have a broad topic. Whatever legal questions are on your mind, we're here to answer them. And the phone lines will be open, 850-392-1544, or you can email us at lawcall@wnbb.com. And I'm really looking forward to those Ask Us Anything questions to see if we can stump my marvelous guest I have here tonight. Lance Berry is a legal wizard and would like to just be challenged tonight with whatever questions you can come up. So, Lance, talk to the audience for just a second.
Well, first, I appreciate Ted's confidence, and we'll certainly do our best to answer anything you have to ask us tonight. And glad to be here, and hopefully we'll get some interesting questions.
Absolutely. Before we get to those phone lines, though, I think we have an email question that came in before we started. We'll go ahead and do that to get us off the bat. This is from Jackie. Jackie asked, if your upstairs neighbor allows their hot water heater to leak to the point that your roof falls in and mold damages your home and all the contents in it, besides contacting your renter's insurance company to file a claim, would you have a claim against your neighbor for negligence as well? And Jackie, that's a good question, and it's a good example of the potential interplay of first party and third party claims.
Sure.
Lance, what do you think about that?
Yeah, I mean, potentially you'd have a claim for negligence if you could show there was negligence. A lot of times, one of the issues that may develop from that is when you're making a first party claim, you don't have to establish any sort of liability. You're able to just make the claim to your insurance company, and they're responsible regardless of whether your neighbor did anything wrong or not. And if your insurance company then pays you, they actually would inherit your right to go after your neighbor if your neighbor had done something improper that had led to those damages. Or you could pursue a direct action against the neighbor if you could establish that they knew that the water heater was leaking and didn't correct it, didn't take reasonable care or reasonable steps to fix the issue that was leading to that leak, and it ultimately damaged your property. And
that's an important thing to remember here is you have a multiple option, at least two main options you can pursue here. You have that contract claim that's your first party claim with the individual company that you've made that agreement with, and that is going to be based off of what coverages you have. And you can have scenarios where you may not have as much coverage as you have damages. Sure. So while your insurance company may pay you for some of your damages, there may be other areas where you have not been made whole. And so those rights of subrogation that the insurance company they may not completely take your rights if there are additional damages, and it's not unusual, for example, for contents coverage to not be as extensive as you need in a loss, and it's something that you really need to discuss with your agent depending on your personal belongings to make sure that you have adequate coverage to help you in a situation like this. But as Lance mentioned, you got to make sure and establish that they did something negligent. It's not a strict liability scenario here. So for example, they had a problem with their plumbing. They were derelict in taking care of it. They let it sit and they let it fester, and a bad problem became worse, and that led to the leak. If that's the scenario we're dealing with, then you very likely have a negligence claim, and it's important that you put that particular property owner's insurance company on notice and make sure and contact someone like us to handle that properly, because that can be a very, very difficult claim to try to navigate on your own.
Sure. And one of the things that was mentioned is about the mold damages. Mm-hmm. And as you pointed out, that's one of the things where oftentimes your insurance policy will not provide as broad a coverage as what it would in just like a wind-borne claim or something like that.
So that's very likely something that is going to have to be pursued on a third-party liability claim. So make sure, Jackie, and you fully explore that. And that's something that a lot of people dealt with, not in this kind of scenario, but the first-party claim with the hurricane damage we had in Michael. We got, unfortunately, another weather system that's coming through now. It looks like it's going to stay away from us, but it's important to make sure and assess those policies, make sure you have the coverage, because if you're talking about a hurricane or a weather system, there's not going to be a third-party liability claim that you can pursue. We know we had many people contact us after the storm and say, my neighbor's trees came and fell on my house. And as a general rule, if you're looking at a natural disaster, that's very unlikely to be a claim. As we've discussed in the past, if there is a situation where your neighbor has a tree, especially after the hurricane where it was either rotten or had some dying aspects to it, hanging limbs, and if they have reasonable notice of that and fail to take action, and then that tree or limb falls on your building, then there's likely a claim there in that kind of scenario, because it all boils back down to whether you took reasonable steps under the circumstances. And a reasonable person, if they know they have a dead limb hanging out of their tree, they need to do something about it.
Right.
So let's hope that we don't have any more issues with that, with what we shall see in this coming storm. But you know, one thing that we are looking at with it is a lot of potential rain, and that's something that you need to talk about with your insurance agent as well, because there is a difference coverage between flood and windstorm.
Right. Yeah, flood damage is water that comes up from the ground or from a river or something like that that comes up rather than coming down from the sky. That is a separate policy, and you normally have to buy it from a completely separate company from what you're buying your normal perils type insurance, your normal homeowner's policy for. And if you don't have that extra coverage, even if there's a hurricane associated with it, if the actual damage to your house comes because the drains in your neighborhood are flooded, mm-hmm. and at that point the water comes into your house and it's because of a flood, then you're not going to have coverage through your normal homeowner's policy. So even if you're not in a flood zone, there's a possibility that you're going to have that issue being outside of a flood zone. Those flood zone maps are not necessarily...
Okay. That's very good, important to remember. While you're finishing that up, Lance, we got our first call tonight. We have Lisa on the line. Lisa, go ahead with your question. Go ahead, Lisa, and turn your TV down so you can hear me.
Can you hear me?
I can now. Go ahead with your question, Lisa.
Yes, I want to know if a doctor had forged your signature without your consent, how do you go about taking legal action or contacting the state board?
Okay, that's a very good question, Lisa. You know, obviously you can't forge somebody's signature. Right. That not only has potential civil ramifications, but also criminal. In addition to, you mentioned another option there, Lisa, from administrative complaint standpoint. So that's something you need to look at and pursue all three. There are forms that you can file with the Alabama Department of Health to put them on notice and file that complaint. If you'll call our office, or we'll actually reach out to you on Monday, and we can get you that information so that you have that form and can file that out. And depending on the facts and the circumstances, there may be a civil claim, because you need not only to have, there's clearly been a wrong here, but you also have to have damages as well, depending on the scenario and what you're dealing with there. And in that same vein, you may need to look at whether or not there's criminal aspects to that. So I'm sorry you're dealing with that, Lisa, but there's never a legitimate reason to forge somebody's signature.
I can't imagine the context where that would be appropriate.
Right. And, you know, there are situations where we need somebody to sign on behalf of them, and that's why we have documents such as power of attorneys that allow you to take legal action for somebody. There are healthcare directives that will let people take directions for individuals when they need medical attention, especially with end-of-life type scenarios. But outside of having one of those legal instruments, it's never a good idea. You know, even as a kid, you don't need to be forging your parents' signature on your homework or your
notes home from the teacher.
So let's don't get into those habits. So Lisa, thank you for that, and we'll follow up with you to make sure you get that handled. We have another call now. Please put that one through. This is Kay. Kay from Geneva. Go ahead, Kay.
All right. Hello. I was just wondering if you have a neighbor that's got a big old pecan tree and oak tree, and the limbs are leaning over our house. Who's responsible for cutting them off, or can he prevent me from cutting them off?
Very good question there, Kay. And a lot of this can depend on whether you're in more rural areas or in the city. But as a general rule, you have, if it's hanging over your property line, you have the right and the authority to trim that up and maintain that. They also can have legal responsibility depending upon whether or not there is some decay or some issues with potential damage. It sounds like what you're dealing with, Kay, is more an issue of aesthetics and maintenance. But to the extent that is coming across and that you can do that maintenance without having to trespass, you're totally within your legal rights to make sure and go ahead and have that taken care of. So I hate that you're dealing with that. It's always best to try to coordinate that stuff with your neighbor, just because you have to live next to them and you want to be in common ground and to have things work together as much as possible. But I would surely recommend reaching out to them first before you take any action to see if y'all can't come to an agreement on how to do that in an orderly fashion. But if not, you do have that right.
Right.
I think we have another call on the line as well. Mike, go ahead with your question.
Okay, I had a hip transplant a few years ago, and the doctor, I did an anterior hip replacement, and the doctor who did it put the wrong liner in. In other words, he put a posterior liner in the anterior hip. It only allowed me 30% movement, 30-degree movement going down my leg before my leg was pinched. So I walked around with a pinched nerve for 2.5 years. I know that it was a type of situation where you get 4 years in Florida if it's an undiscoverable situation, and it's not being able to, you couldn't discover it unless you just dug in there and found it. So anyway, it's Andrews here in Pensacola.
And what's your question, Mike?
I'm just wondering if there's any recourse against a doctor who put in a wrong part.
Okay.
Well, generally speaking, on a medical malpractice claim, you have 2 years from the date of discovery, and the question ultimately becomes, did you discover it, or should you have discovered the issue? And if you are within that 2-year period from when it was reasonable for you to realize that a medical malpractice, some sort of negligence had taken place, then you would still be within that statute of limitations. But it's definitely important that you act very quickly, because if it's already been in your body for 2.5 years, there may have been some warning up to this point that something was wrong and you should have pursued it earlier. But that would be something you would certainly want to move quickly, and whether or not you'll meet that deadline or be able to show that the statute shouldn't have started running until a later date, that is a very fact-intensive question, and it's something that you'd have to have an experienced medical malpractice attorney look into in order to really fully understand what's going on and what could be done.
Right, and then if you figure out that you are within the statute of limitations in Florida, in order to pursue a malpractice claim, you will have to get another professional in that same specialty that's willing to raise their right hand, sign an affidavit, and say that individual breached the standard of care when they did that. From what you're saying, it looks like that's a very high possibility that you'd be able to meet that threshold. And then the issue becomes, what are the damages? And it sounds like you have suffered some pretty severe consequences as a result of that. But the biggest concern that Lance rightly pointed out, and I think you were already aware of, Mike, is that you need to act fast, because that's going to be a fact-intensive question based off of what you knew or what you should have known under reasonable circumstances. And obviously this is something that's in the interior. There can be some discovery issues there, but you're aware of it now, so you want to act quickly and make sure you can get that resolved one way or the other. Do we have another call on the line as well? Pat from Fountain. Go ahead, Pat.
Hi, I'm elderly, do not have a lot of money. When I pass away, if I write it down on a paper what I want, I've got certain things I want to go to certain people, and put it in my safe box, or do I have to write it down and get it notarized, or do I have to go to a lawyer? That's it.
There you go. Very good question, Pat.
Generally speaking, just writing it down and putting it in the safe deposit box, that's, your friends and family may honor those wishes, but legally they wouldn't be required to. You do need a formal will. There are certain statutory requirements that you have to meet in order for it to be considered a will. It would normally have to have 2 witnesses. You have to sign in their presence, and there's a bunch of other formalities that go into that. You don't necessarily have to have an attorney, although we'd certainly recommend that, and that is the best course of action. Right. But you do have to at least meet those minimum requirements in order for it to be considered a will, and then that's proved in court to be, hey, this is her last will and testament, and if that's how you've laid it out in the actual last will and testament that meets all those requirements, then that would be what we control at the end of the day. But just writing it out on paper and putting it in a safe deposit box, right, at best that's just going to be something that your family and friends could potentially honor. But if they don't, there's actually a statute that specifies how your property would be distributed at your passing.
Right, and so that's what's important. You can do a handwritten will, but if you do that, you still have to follow all the will formalities, which is the 2 witnesses. It's best to have it notarized as well so that you have it what's called self-proving, which means you can have it admitted into probate. But I would recommend highly that you speak with someone briefly. That's something you can do pretty easily and get you some help with. But as Lance denoted or mentioned, you know, there's statutes that say, like, for example, if you have kids, it goes to your kids pretty much evenly if that's the scenario. If you have a spouse, it goes to your spouse. So there's intestate statutes that govern what happens if you don't have a will, but it's important that you take care of those things in advance so that you can have it go exactly where you would like to. Well, we've been getting a bunch of calls here, and let's keep that up. We're going to take our first break, but we'll be back on the phone lines when we come back, 850-392-1544. Welcome back to Law Call. Once again, this is Ask Us Anything, and y'all have been very good about getting in on those phone lines, 850-392-1544. Please continue to call, and it's not often that I get the opportunity to have Lance Berry here with me, and when I have Lance here, I want to make sure we get all of Bay County and the surrounding areas and South Alabama's questions answered, because you don't want to waste an opportunity like that. And they've been taking full advantage of it thus far. But, or if you do not want to call, you can also email us at lawcall@wnbb.com. So once again, you know, we've been talking about a few things. You know, we've talked a little bit about medical malpractice. We just talked a little bit about estates and trusts with respect to wills and how you do that. Another issue that we deal with day in and day out is making sure that people have proper coverage on their auto policies.
Right.
And you know, one thing we can't preach enough is making sure that you have on your policy uninsured motorist coverage, because the reason we buy insurance for anything, for example, our house, we've talked about flood and windstorm, is those are things that we want to protect, and we don't have necessarily the financial means, if we were to hit a devastating storm, just replace those with cash. Same instance with your body. If you have mounting medical bills and you get into an accident, you want to make sure you have coverage, not only to make sure that those expenses are paid, but that you also are compensated for any time you're out of work, not to mention the pain and suffering and the aggravation of going through one of those accidents. And Lance, as you know, we don't have mandatory bodily injury coverage here, so that's one of the risks, the biggest risk you can do in any given day.
Yeah, very unfortunate in Florida. Most states, you know, have gone the way you do have to have at least some minimum liability requirements as far as bodily injury liability coverage, property damage liability. in Florida, at least, you are required to carry some property damage liability coverage, and if you're involved in a wreck and the other person is at fault for that, then they will have coverage for almost certainly for a little bit of the damage, up to $10,000. That's just the state minimums. But as far as the bodily injury liability coverage, there is no requirement that anyone carry that in order to be legal and driving around on the road. So one of the things you can do, as Ted's already alluded to, is buy uninsured motorist coverage, and that's a protection for you in case that person does not have enough bodily injury liability to coverage to cover all the damages they cause to your person. You know, they may still have some coverage for your property, but if they don't have that coverage for your injuries, then the uninsured motorist coverage will step in and help pick up the medical expenses and pay for the damages to compensate you for your pain, suffering, mental anguish, loss, enjoyment of life, those
all
sorts
those
of
good things. Well, while we were doing that, we had another phone call come in from Sean. Sean, go ahead with your question.
Yeah, good evening, guys. I recently moved from Denver, Colorado to Panama City Beach, and I have an LLC that's tied to the address I have in Colorado that I'm currently selling. My question is, do I need to dissolve that LLC, or is there a way I can do an address change just to pull that LLC down to Panama City Beach?
Well, that's kind of a complex question there, Sean. A lot of it will deal with, for example, what the nature of that LLC is, what kind of assets it owns. A lot of times you can just have it registered to do business here in Florida, or quite frankly, if it's all in Denver or Colorado, the entity exists separate and distinct from you. So that entity continues to, quote, be a resident of Colorado even though you have moved here. So the likely answer is that you probably are okay with it just like it sits, but I would want to make sure that a lot of that can get the devil's in the details, making sure what that particular asset is that you're selling, what it owns, real estate versus personal property versus intangible assets, and make sure that not only that you get advice from a legal perspective, but also from a tax perspective, because you can have tax implications between the different states to make sure that you have that governed correctly.
And I think the question, as I heard him, was more towards, whether he could, it sounds like he's moved here, maybe the business is still out there, and just what's the process for making sure that basically the official correspondence finds its way to him. And there should be, if that's all that's involved, there should be a way that you could submit an update on with the Colorado Secretary of State or whatever their equivalent would be.
So make sure you get that
update
updated.
your address.
Yep. And we got one more call on the line we're going to try to hit. Kat, go ahead with your question.
I was checking on the First Lady Bird deed.
Yes, ma'am. What's your question?
I was wanting to check on the First Lady Bird deed.
Yes, ma'am. A ladybird deed is something that's very popular now, and that's a situation. It allows you to kind of go ahead and leave your property with what's called a life estate to yourself, so you have it for your life, and then you can give a remainder interest to whomever you would like, most frequently your children. But the specialty in the ladybird deed is it still allows you to retain the right to sell that property if you choose. Normally in a life estate you give up the right to sell it because the remainder interest, which is the interest after you die, is going to go to whomever you designate in that deed. But a ladybird is a special form of that deed that allows you to continue to retain the right to sell that property. So it's something I would highly recommend that you look at. It's what we call a probate avoidance strategy, which is very helpful to your loved ones and your family. So please we'll reach out to us. We can put you in contact with a good lawyer that can help you with that. We're going to now take our last break of the evening, but those phone lines will still be open, so if you need us, give us a call, please. Welcome back to Law Call. During the break, we got a call from Pat from Washington County, I believe. Pat, go ahead with your question.
Yes, I live in Florida, but I had surgery, replaced my knee surgery 3 years ago. And after they replaced it, they found out they put the wrong size in. They went back and put the right size in, and then I got an infection. They went back and took that out, and I had to be on a PICC line and everything. And then I was very sick, and then now they're telling me that they need to go back again, put me on a PICC line, IV antibiotics for another 6 to 8 weeks, take out the pieces that's in here, and do another surgery, which would be the 5th surgery. And I want to know if my surgeon is liable for what he's put me through, because each time it was like, should I?
Pat, potentially. This is going to be governed by Alabama medical malpractice cases, which also have a 2-year statute of limitations. So I'm really worried about the timing issue there. So make sure and reach out to us quickly so we can look at that in more detail. There can be some limited discovery issues, a little more strict in Alabama than in Florida, but there's absolutely the potential right. The issue may be whether there's a statute of limitations issue, but if you do violate medical malpractice in Alabama, you don't necessarily have to have that affidavit, but it's important that you look at that quickly. We're right here at the end of the show. Lance, you got any shout outs real quickly?
Just say hi to my wife and kids back home in bed, hopefully.
Very good. Hope so. Yeah, my wife and kids better be as well. My son Judson's off at camp. But we'll see you next week. We'll have Johnny Joe Bear on the show here from Louisiana. This should be a good one, so make sure and call in and get your questions. And we will see you next weekend.